Hello, everyone. My name is Teilen Celentano, and welcome to today's iteration of the live employment law Q&A by employmentlawyer.ca. I'm an associate with our firm's office in Toronto, and I'll be answering any of your employment law questions today live. So if you have any questions, whether on Facebook, LinkedIn, X, Twitter, YouTube, go ahead and ask them, and I'll answer them right away. You can also go to our website at employmentlawyer.ca, email us at help@employmentlawyer.ca, or call us at 1-855-821-5900. I would like to talk about two things today that kind of are front of mind and have been reported on in the news and raise a couple interesting employment law issues. So the first thing is about there was a teacher in Quebec who was cast on the Quebec Survivor show. And for that, she requested a 2-month leave so she could go compete on the show, which had a grand prize of $100,000. The school board swiftly rejected that request, saying, no, there's a teacher shortage. We can't have you going on Survivor for 2 months in the middle of the school year. It was from January through March. She nevertheless decided to go. She found her own replacements through her own channels and went on Survivor. So shortly after she left, the school board had a meeting and voted in favor of terminating her employment. So the question is whether or not an employee in Ontario could be fired for cause for the same thing. It's important to mention that in Quebec, they're the only province in Canada that has their own legal system. So all of Canada operates under what's called a common law legal system, descending from the British common law legal system, whereas Quebec is a civil law jurisdiction or code law, with their laws descending from the Napoleonic Code in France. So laws in Quebec are very different than laws in the rest of Ontario. But that issue aside, if this were to happen to an Ontario-based employee, could their employer terminate them for cause? Cause is generally an incredibly high bar for employers to meet. Our courts have called it the capital punishment of employment law. With that being said, taking a 2-month leave of absence that is unsupported and unapproved is likely one of the few scenarios in which an employer would have cause. Or in the alternative, they may also be able to establish that the employee abandoned their job, thereby effectively resigning. And in either case, the employee would not be entitled to severance. There's nothing that, by rule prohibits employees from going on game shows and competing on Survivor or The Amazing Race or whatever other reality TV show you prefer, but they need to get permission from their employer to leave. And if the employer chooses to withhold that, well, then the employee does it anyways, it might be cause. Similarly, if you were to say you needed a stress leave or a medical leave and then went on Survivor, that type of dishonesty may also be cause. So the short of it is if you get cast on a show like that and your boss says no, there's nothing stopping you from resigning from your employment and going on the show. But if you nevertheless go, despite not your employer not approving, it could lead to your dismissal and disentitle you to a severance package. The second topic I'd like to discuss before getting into your questions is the recent news that came out, as was reported by the Toronto Star, regarding FIFA's request for exemptions from employment law during the World Cup. So, as you may know, Toronto, Canada, the US, and Mexico were awarded a joint bid to host the 2026 World Cup, so in 2 years. And as part of that, FIFA requested to be exempt from labor and employment laws. Now, the details of those exemptions haven't been made clear, but in the emails and information the Toronto Star was able to obtain, it showed that the city's Toronto's then mayor, John Tory, was worried that there were exemptions and that FIFA wanted exemptions to the Employment Standards Act. Thankfully, recently, a spokesperson from the provincial government has come out and said there's been no exemptions granted by this government, and that's a really good sign. It is the provincial government that is responsible for that is responsible for regulating employees in Ontario, or the vast majority of them. And if they haven't granted any exemptions, it is likely that FIFA will have to follow our employment laws. The ones most at issue weren't identified, but the ones that they likely wanted exemptions to, and again, all speculation on my part, but it was likely what overtime pay, vacation pay, public holiday pay, and then also work safety standards. Those are probably the biggest things that are provided for under Ontario employment law that FIFA may want to be exempt for. A good example is overtime pay. So in Ontario, if you work more than 44 hours per week, you're entitled to time and a half for every hour you work in excess of 44. So if you're an employee who earns $20 an hour and you work 50 hours in a week, well, for the first 44 hours, you get paid $20 an hour. And then for the last 6 hours, you get paid $30 an hour. So your regular time, 20, plus an extra 50% and 10 is 30. So something like that can obviously vastly increase the operational costs of an event like FIFA. And the other thing too is under the Employment Standards Act, we have a number of provisions regarding unpaid work, right? You can't perform unpaid work. Employers or FIFA isn't allowed to do that. So if you can't just be a volunteer so you can get tickets. You really need to be getting paid for that. So the short of it is, as of right now, there have been, or as of early March, there were no exemptions given by the provincial government, and there haven't been any announced since. So all the people who do choose to work at the World Cup will be entitled to protection by our laws. So it's a really good sign, and hopefully that doesn't change. Our first question is from Snuggles on YouTube. They ask, I'm being let go at the end of my 3-month probation period. I feel like I wasn't given a fair chance. Do I have rights? So under the Employment Standards Act, if you're terminated early, within the first 3 months, you're not entitled to anything. And most contracts have a probationary period that articulate just that they can fire you without cause and not provide you with anything in the first 3 months. What our courts have said in interpreting those clauses, is that it must be undertaken in good faith. So an employer can let you go during that probationary clause and not provide you with anything, provided that their assessment and that their appraisal of your performance is done in good faith. Meaning they didn't just hire you for 3 months and then let you go, and that was the plan the whole time, or you weren't actually given a fair shot to show your worth and to contribute to the workplace. So in your case, Snuggles, if you don't feel like you were given a fair chance, there's a possibility that they didn't give you that good faith opportunity to contribute, and that you would be entitled to a severance package. How much severance you're entitled to, it depends vastly. Our courts look at a number of factors in order to ascertain how much pay in lieu of notice of termination someone is entitled to. In some cases, it can be as much as 24, 26 months. It can be as little as 1 to 2 months. And how much each person is entitled to depends on the terms of their employment. So for you, likely best to give us a call or reach out to us at employmentlawyer.ca, and one of our lawyers will be able to discuss your situation with you and advise on, what your entitlements may be going forward and how we may be able to help you out. Jordan on Facebook asks, if my employer reduces my pay by 10% and then later reduces it further, would that be allowed, or is it a constructive dismissal? So Jordan, whenever there's a substantial change to the terms of your employment, it's a constructive dismissal. And that's what our courts are looking for. The operative word is substantial, right? So if it's a 10% reduction in pay for no reason, it is likely that is enough to establish a constructive dismissal, right? There's no bright line. There's no hard and fast number where if your pay gets cut by 9%, it's not, and 10% it is. It's always contextual. Right. So our courts will recognize that 10% of, $50,000 is $5,000, obviously. But that means a lot. That cut may mean more to someone making less than someone making more. So it is contextual and it does depend. And it also matters too is how that change is coming, right? If it's just they're reducing your hourly rate from $20 an hour to $18 an hour, or if they're cutting an entitlement to overtime, may be different, or if they're changing a bonus or commission structure can also change. So the way that 10% change manifests can largely influence whether or not it's a constructive dismissal. But if now your employer is trying to do it again, right? Maybe they're trying to drop you another 10%, then it's very likely that that is a constructive dismissal. Again, every constructive dismissal case is a highly individual and factual analysis, right? We really need to look at each one on their merits. But if they're going to keep reducing your pay, then it's likely a constructive dismissal. The one thing you should do is reach out to us right away at employmentlawyer.ca. Excuse me. And we'll be able to discuss it with you. One of the dangers with all constructive dismissal cases is a question of acquiescence, right? So our courts have said that if an employee acquiesces to a change, then they're stopped from thereafter relying on that same change for constructive dismissal. So in your case, Jordan, they've reduced your pay by 10%. Maybe that happened a month or two ago, and you've kept on working throughout. So the court would likely say you've acquiesced to the first change. And if they do it again, right? So if they say after a couple months, we're reducing your pay by another 10%, Jordan, it's important that you reach out to us pretty much right away. Because if you continue work, if you wait too long to call us, and then, it's been a few months that you've been at this new twice reduced rate of pay, we may be hamstrung and that we can't do anything because you've acquiesced to that change, and the time essentially for a constructive dismissal has run out. So in your case, absolutely give us a call and try to do it as quick as you can and speak with us about what your rights are and what your next steps could be. Lily on YouTube asks, is it legal for a company to let you go for no reason? I've worked in retail for at least 4 years and our location is being sold back to corporate. They're letting a number of staff go for no reason. So Lily, the answer is yes, they're allowed to let you go, but they're not allowed to do it for free. So in Ontario, for provincially regulated employees, employers are allowed to let them go without cause, which means they don't need to have a reason for letting you go, hence without cause. Now, they can't let someone go for a discriminatory reason, right? They can't let someone go because they've requested to take a paternity leave. They can't let someone go because they need time off to take care of a family member. But if there is just genuine corporate restructuring, which is what it sounds like here, a retail location is being sold from a franchisee back to corporate, and they're choosing to let people go, they are allowed to do that. And what makes that dismissal a wrongful dismissal is not providing that employee with enough severance, right? So right off the top, Lily, you would be entitled to your minimum entitlements under the Employment Standards Act, whatever those may be. But then in addition to that, you're likely also entitled to additional severance under the common law. So if this is a situation where a company is changing hands and your job is being cut as a result of that, it's important that you give us a call and speak with one of our lawyers. We'll be able to advise on what your entitlements are in such a scenario. Peter on YouTube asks, is there a Minimum Standards Act law for discipline for employment in Ontario, i.e. being suspended without any form of written warning? So Peter, there's no rule that sets out the steps companies need to follow, whether under the Employment Standards Act or under the common law. There is no formal policy that every company in the province needs to follow. That said, there are generally accepted principles that companies need to follow when disciplining an employee. Generally that system, while it can be different, it's not, like I say, it's not prescribed, but it's generally, a verbal warning, a written warning, a suspension, a final warning, and then a termination. It's generally how it goes. There may be more steps. There may be, steps taken in different orders, but that's kind of the overall structure. There may also be a performance improvement plan. So if your company has jumped straight to suspending somebody without pay, it's likely that their action just in doing that is actually constructive dismissal, right? If they haven't followed an appropriate disciplinary process and just jumped right to withholding pay and suspending you from work, it is likely that that is a constructive dismissal, and you could actually trigger a constructive dismissal and a termination and a severance entitlement just based on that. So if that's happened to you, Peter, reach out to us at employmentlawyer.ca, and one of our lawyers will hopefully be able to help out. But irrespective of that, they do need to give you something in writing. And if they aren't, then it's important that you ask for it, right? Under the Employment Standards Act, it does stipulate that all notice of termination must be given in writing, but there is no same thing for a suspension because it's not actually mentioned in the legislation. So for you, Peter, I think it's really important that you, one, get that in writing. Reach out to HR, reach out to your supervisor, and really demand that you receive it. And also contact us at employmentlawyer.ca to see if one of our lawyers can help you out, whether or not you might be able to start a constructive dismissal claim. Francine on YouTube asks, my employer has replaced my position at work and deemed the position male staff only and reassigned me into a position that does not meet my accommodations. So Francie, your employer is discriminating against you in multiple different ways. So starting first with the male staff only portion. So under the Ontario Human Rights Code, gender and sex and gender expression and gender identity are all protected grounds of discrimination, meaning you can't be treated differentially because of any of those things. So if an employer has something as male staff only and are by that very definition excluding female staff from that job, that's discrimination. It's differential treatment. So, and the only time that type of behavior can be ever justified is if it's a bona fide occupational requirement, right? So that, again, I don't know the nature of the position and I don't know, what position you were filling, but if that had been a position you were in for years and then for whatever reason the employer decided to make it male staff only, then it's likely that being a male is not a bona fide occupational requirement. It's just their preference or it's just their whatever, but they're not allowed, they are just, to meet that, they're discriminating against you and against other women, and that's not allowed. Secondly, under the Human Rights Code, you're entitled to be accommodated. It's not an option for the company. They don't get to decide whether or not they can accommodate someone. It's an obligation. They have to. Accommodation can take many forms, and you can be accommodated for a number of different reasons, whether it's for a disability, right? Maybe you can't carry things. You can't lift things over your head. You can't twist. Maybe you need a standing desk even. Any of those are forms of accommodations for physical disabilities. In addition to disability, you can also be accommodated for other reasons. For example, if you're a parent who needs to start leaving work early in order to pick up a child from school or from daycare, you can request accommodation on the basis of family status, right? My family status as a parent requires me that I pick up my child from school at 3:30, and I'm therefore requesting that instead of working 9 to 5, I work 7:30 or 7 to 3 so I can get to my child's school by 3:30. That is a legitimate form of accommodation and something that people are entitled to. And employers must accommodate people unless doing so would result in what's called undue hardship. Now, again, similar to being a bona fide occupational requirement, that's something that is described but not defined in the Human Rights Code. But the way it's been interpreted by our courts is that for something to be undue hardship, it really needs to mean that it would cause significant harm to the company. And it's not just mild inconvenience, right? So, if you're an employee who has a compromised immune system and then doesn't, their doctor's recommending that they don't go into work because of COVID, because of the pandemic. But an employer nevertheless is trying to force you back to work. If your doctor is going to write you that note and you've already proven that you can work from home, then the employer must let you work from home, and failure to do so is discrimination. So what do you do when your employer is discriminating against you? Well, there's a number of things you can do, but most commonly what we do is we start what's called a constructive dismissal claim on that basis, on the basis that you've been discriminated against, that your employer has, for no genuine reason, not only taken you out of your job, Francine, because you are not a male, but also taken away your accommodations. That is, illegal, is contrary to the Ontario Human Rights Code, and there's no reason for them to do that. And you'd likely be able to start and be successful in a constructive dismissal claim. Sam on YouTube asks, what is the best definition of consensus to a unilateral cause? Sam, I'm not sure what you mean by that. Consensus to a unilateral cause. If we're just talking just cause for termination, just cause is behavior that strikes to the core of the employment relationship, or misconduct that strikes to the core of the employment relationship such that the continued employment has become untenable. Obviously, a lot of big words there. Those are the kinds of words our courts frequently use. But either way, whatever definition you want to give it, it's incredibly hard for employers to have just cause to terminate someone. And our courts have likened it to capital punishment. They've said termination for just cause is the capital punishment of employment law. And just like capital punishment is reserved for the most heinous of crimes, termination for just cause, the capital punishment of employment law, is reserved for the most heinous of misconduct. So not sure exactly what you meant, Sam, but that's the best I can do to answer your question. Dan on YouTube asks, my employer laid me off in December when I asked about being called back. They said I would not be called back to work. They told me I'm only entitled to 2 days of severance for every year I work because that is what the CRA said. I've been there for 10 years. Is this right? So, Sam, it sounds like you're a federally regulated employee. So depending on the industry you're in, you can be either provincially regulated or federally regulated. Generally speaking, employees who are in aeronautics, so whether it's airplanes or space travel, anybody in banks, anybody who works for railways, a couple other sectors as well, they're what's called federally regulated employees. So their terms of their employment are governed by the Canada Labor Code. And then everybody else, if you're not federally regulated, then you are by default provincially regulated. So just based on how they describe what you're entitled to of 2 days for every year, I think you're likely federally regulated. So your employment standards, your minimum employment standards are provided for by the Canada Labor Code. With that being said, there is a misconception amongst many employers that people are only entitled to their minimums, whether it's under the CLC or under the ESA, and that's incorrect. In addition to that, there's also something called the common law. As I mentioned earlier, Canada has a common law legal system. So we are in those two, and the common law also provides for severance. In the common law and the statutory severance periods run concurrently to one another. That is to say, at the same time. So if you've been there for 10 years, Sam, and your boss is saying, well, you only get 2 days per year of service, well, that's 20 days. But, whenever that starts, whatever that termination date is, then, those first 20 days is the minimum they have to give you. But running at the same time and overlapping and exceeding that is the common law. Well, courts look at more than just years of service. Someone who's been at a employer, who's been working for an employer for 10 years can expect to receive anywhere from 8 to 12 months severance. So the way it would work is if your employer paid you out those 20 days, and then when you went to court and a judge said, okay, Dan, you're entitled to 12 months severance. Well, then the court would say, okay, well, what's 12 months? Great. We're going to subtract those 20 days paid Dan has already got, and he's entitled to the rest. So I don't think your employer is lying to you, and I don't think they're trying to mislead you. I think they've just been given bad advice by the CRA. I think you should give us a call or go to our website at employmentlawyer.ca, where you'll be able to set up a call with one of our lawyers. They'll be able to tell you exactly what you're entitled to. And then also, depending on why they laid you off, you may also be entitled to something additional. If it was for an injury and they're refusing to return you, that could be classified as discrimination. But if it was just a general layoff, potentially not. But either way, Dan, reach out to us and one of our lawyers will be able to help you out. Craig on Facebook asks, my friend has been a loyal employee with a great record with his company for 7 years as a shipper receiver. He recently has been having some medical issues. His doctor issued a medical note for 6 weeks. The day the doctor's note was received, his company fired him. He was offered 6 weeks pay. In addition, he was offered 6 weeks pay. In addition, he was offered 3 weeks pay to sign a full and final release. He's 55. Was this legal? No, not at all. No, not at all. Employers must accommodate employees. I said that earlier. When answering Francine's question, it's not optional. They have to do it. So if your friend asked to be accommodated and they just said, you know what, we're not doing it, here are your walking papers, that's woefully illegal. And in addition to that, so that's the discrimination, and he's also entitled to severance in addition to that. And he was offered 9 weeks total for someone who's been there for 7 years. It's just not enough. So if your friend has signed that full and final release, he may be out of options. But if he hasn't, he's still thinking about it or still sitting on it, he shouldn't sign that. He shouldn't take that deal. One of our lawyers will be able to help him out and get him significantly more. That's absolutely illegal and an incorrect way to not only treat employees, but just humans in general. So I've got time for one more question for today. And it's a question from Jeff on YouTube. I'm self-employed and accepted a 3-month contract for a senior director role. I was promised a renewal, shut down my employment business, and worked beyond the contract. In month 5, I was terminated. I know the contract became indefinite. So how much severance am I entitled to? Jeff, it depends. So like I've mentioned, how much severance you're entitled to depends on a number of factors, right? Not just how long you were there, but your age, the level of your role. And then obviously in your case, the fact that you shut down a business under which you were self-employed, will make things significantly harder going forward. So in your case, Jeff, I think reaching out to one of our lawyers could go a long way. In some cases, employees who are relatively short service is being awarded as much as 6 or 8 months total compensation when they're let go. That's a somewhat new development in the case law, but our courts have said we don't want an employee's short service taking on an unduly large weight in assessing the reasonable notice period. So again, Jeff, I would need to look at everything, all the circumstances of your employment, the industry, your role, what your duties were, how much you got paid, all that kind of stuff before I could really give you a good estimate. But, anywhere from 3 to 8 months could be a fair range. Again, it just depends on a bunch of factors that we'd have to sit down, discuss, and take a look at. So I think in your case, Jeff, reach out to us at employmentlawyer.ca. One of our lawyers will be able to take a look at everything, also take a look at your contract and ascertain how much you may be entitled to, and then also what the best way to get it is. So that's it. That's my time for today. Thank you all for joining. If you have any questions, hold on to them. And next Wednesday, Lee or Samfiru will be hosting another live employment law Q&A at 1 p.m. Again, our website's employmentlawyer.ca. You can email us at help.employmentlawyer.ca, or you can call us at 1-855-821-5900. Thanks. I hope you all have a great rest of your day. Bye-bye.